of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Today, our topic is partition actions. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook, and you can find us on YouTube. You can also find us now on Twitter, and you can find us at the handles at InRem Podcast. That is at InRem Podcast. Make sure to go there. Make sure to subscribe. That helps us provide you more and better content. With that, we're going to turn it over to Sean, who has our legal update.
Thank you, Andy. So my legal update today is a continuation of my What If series. And so today it's going to be, what if a seller of a subject to transaction dies after the close of escrow? So in a previous episode, I asked, well, what if the seller dies prior to the close of escrow? Now the question is, what if a seller on a subject to transaction dies after the close of escrow? So after the close of escrow means that title has transferred from the name of the seller to the buyer, and the buyer then owns the property subject to the existing loans for which the seller is the borrower, and the seller has now passed away. So what does that mean? Does the lender just automatically call the loans? Does the seller's estate have a right to rescind the transaction? What happens if a seller dies after escrow closes? As to the buyer and the seller and their relationship, basically it depends on how the contract or the transaction was structured. But if it was structured as a subject to closing with a wrap, which is what I recommend and how I recommend closing the transactions, which means that the buyer has given the seller a promissory note, and that promissory note is secured by a deed of trust or mortgage against the property, basically making the seller the lender. And that promissory note states what the buyer's obligations are as to the property and as to the existing loans. Basically, it says the buyer will, the promissory note says that the buyer will pay the monthly payments to the lenders and will satisfy all obligations of the existing loans. So it's generally what we call a performance note, which it obligates the buyer to perform in a certain way. And basically that's to make the existing lender whole and to write the monthly payments to the existing lender, to make sure to keep the property insured, to do everything that they're required to do as a borrower under the property. Well, that promissory note is a tangible personal property. So a promissory note is basically an obligation by one party to pay another. And so the party that holds it, we call them the holder, the party that holds the promissory note, so the lender, has that promissory note, and that promissory note is an asset. And so when the seller passes away, that is an asset of the seller. And then that asset goes in and becomes part of the estate, and then will be distributed according to either a will or a trust, or if neither of those exists, the state where the seller passed away, their intestate succession laws, the note will be passed on to the seller's heirs. And then the heirs of the seller can enforce the note if the buyer isn't paying. Basically, they make sure that the buyer is doing what they've agreed to do and obligated themselves to do at the time of closing the transaction. As to the existing lender, really nothing changes. The buyer is already making the loan payments. Generally, the purchase contract or the subject to addendum is basically going to, the seller's going to covenant and warranty that, they're not going to do anything to in any way, impact the buyer's rights to the property. They're not going to go and try to, have the lender invoke the due on sale clause. They're going to basically cooperate so that the buyer can perform and not interfere with the buyer's performance under the contract. Well, that clause would be binding upon the seller's heirs. So they can't then call up the lender and say, hey, the seller died. Why don't you call the loan due or something like that? They're not supposed to do that. That would be a breach of the documents that they signed. Instead, basically the process goes on as normal. The transaction goes on as normal. The buyer writes their payments to the lender or to the servicing agent, if one's been appointed, and the servicing agent then writes the checks to satisfy the loan obligations. If the subject to transaction was done with a promissory note secured by a deed of trust or mortgage, then that promissory note is distributed by the individual with authority to manage the affairs of the deceased seller's estate, and it's given to the deceased seller's heirs or beneficiaries, and then they have a right to enforce it, but only if the buyer breaches, only if the buyer stops paying. Nothing changes. Basically, the transaction has already been fulfilled, it's closed, and everyone just goes on and continues to do what they're doing. The only difference is now, instead of the seller, who is now deceased, holding the note, the seller's heirs or beneficiaries of their estate will hold the note to make sure that the buyer is performing.
At the end of the day, we've all seen this actually in real time, but it's really not a whole heck of a lot different than when your typical mortgage that you have on your home is then owned by a new lender or is being serviced by somebody else. You might get notice of it. Maybe if they're keeping the same servicer, maybe your payments go to the same place. Maybe it changes, but you're just really being put on notice of a new owner, and you continue under the terms of the deal. It's really not a lot different than that, is it?
No, I mean, promissory notes are bought and sold and assigned on a regular basis. Hundreds, if not thousands, if not hundreds of thousands on a daily basis are being bought and sold, both privately as well as, in securitized transactions. And that's the thing about a promissory note. It's a tangible piece of property that can be bought and sold and transferred and conveyed. So like you said, it's really no different than what goes on a regular basis with these large lenders where they, sell off their promissory notes to a new lender or to a new servicer. And they update the records to reflect that. And the payments are then made, accordingly. And yeah, it's basically the same thing when somebody passes away. The note is just transferred to their heirs and beneficiaries.
Yeah, good stuff. Well, speaking of subject to transactions and creative finance transactions, we've been talking to you, the audience, about the Creative Finance Collective. And as we approach that, we've discussed on a number of episodes now that in July, we'll be rolling out the Creative Finance Collective in its full form. But as a first episode of the collective, we are hosting and will be conducting an episode here tomorrow with our friend and buddy Alan Seshker out of Texas. Alan's the rap nerd and the creator of the Rap University, and I think we both all agree probably the go-to guy when it comes to knowing how to do rap transactions and teaching on how to do rap transactions. So our first installment of the Creative Finance Collective is going to be tomorrow, May 24th at 5:00 p.m. Arizona time. And there's going to be a couple of different ways that you can participate, and we'll talk about that. But we want to give you kind of a description on what it is and what it's going to be. We didn't want to do another presentation. We didn't want to do another formal offering. What we realized in really doing the NREM podcast and meeting a lot of people throughout the country is there's a lot of minds, legal minds and professionals out there that are doing creative finance and are working through the specifics. They're working through the nuances of creative finance within their respective state and jurisdiction. And there's a lot of thoughts on how to go about things. And Sean and I have really enjoyed kind of that process of learning from others and talking through some of these issues. And we thought, wouldn't it be neat to have a collective, a group of minds that get together and talk like they would in a basement or any other time, to talk about this and give you, the listener, the opportunity to, one, be a part of it and listen and learn, but also to interact, ask questions, and be a part of it. So that is the idea behind the collective, and we're excited to offer that. In our first episode, like we mentioned, Alan's going to be with us. In the future, we're inviting and have invited a number of legal minds to be a part of the program to do that. Now, the two ways that we're providing you access to the program are one, through a live link that allows you to kind of be part of the show itself, where you can sit and watch the show kind of in the background, but have the ability to be brought up, ask questions live, and interact with the members of the collective. The alternative way to watch and be a part of it is to just watch the show on the channels that we will be live streaming it on. And that's going to be Facebook, that's going to be on YouTube, and that's going to be on Twitter, really our primary channels. But you're going to need to go to those and to subscribe to be able to watch that. But throughout the entirety of the show and all of the shows, we will make it open to you, the listener, for questions and interaction along the way. Sean, do you have any additional thoughts on the collective?
Yeah, it's a unique opportunity for our audience, for investors, to basically listen to attorneys talk about this on a high level. It's really going to be just an open discussion with attorneys on different topics regarding creative finance. We might compare and contrast what's happening at Arizona versus Texas or other states when it comes to creative finance, real estate investing, those types of things. And, the first week with Alan is going to be awesome. Like you said, I do think he's the leading authority on wraps nationally. And in fact, I flew to Dallas to attend his Wrap University, which was a one-day program. It was awesome. I learned a lot, even though I do this, type of work on the regular basis, and do a decent amount of it. I still learned tons from attending that class. He now has rolled that out so that it's available online, where you can go. If you can't make it to Texas and attend in person, you can go and register and take it online. And I would encourage any of our audience who is doing creative finance transactions to go register, attend in person, participate in Wrap University, come participate tomorrow night in the first Creative Finance Collective. And then, I'm going to be out of the country for much of June. And, June's kind of a downtime even in Arizona because people are on vacation and kids are out of school and people are trying to get out of the heat. And so, we're not going to offer the collective in June, but then we're going to start up and really dive in with other attorneys come July. So definitely don't miss that. Don't miss tomorrow night, which is kind of our initial, kickoff show. And, come be part of it, come participate, log in, have a behind the scenes look, which would include even some, discussions that we're going to have probably with Alan early on before, we even go live. And then, you can ask questions. We'll bring you forward. You can be part of the show, or you can watch, online. You can stream it, watch it, through YouTube or InRim, Facebook. But it's through the InRim channels. So, make sure to go onto YouTube and subscribe to that page, like our Facebook page. That way you can, make sure to be able to watch it and be notified when we're going live on that. And then if you do have questions, you don't get to be part of the show per se. You can post them in the chat features of each of those platforms. And we should be able to see those on our end and then ask those questions. So yeah, come out, participate, be part of this tomorrow.
Yeah, it'll be a good time, and we're looking forward to having you all there. So today we're talking about partition actions. And in addition to what we just talked about, the importance of being able to participate and ask questions, we're taking questions today as well. So as a how to go about posting your questions, I'm going to turn it over to Mayu, who can walk you guys through, and we'll walk you through on what we want you to do to post your questions for today's show.
Thank you. Happy Tuesday. It is May 23rd. You guys are watching the NREM podcast. And if you've joined us on the show before, then you know that we do take questions live on the show. So whether you're watching us from our Facebook pages or YouTube, you can drop your specific questions in the live chat. I am monitoring the chat for your questions so that we can take the last 10 to 15 minutes at the end of the show to answer them. Today's topic is regarding partition action. We take questions in order of priority, so don't wait. If you have a great question in mind related to the topic, make sure to leave it in the comments and we'll try to get to all the questions at the end. So back to you, Andy.
All right. Thank you, Mayu. With that, let's get into the topic at hand. We're talking about partition actions, and partition actions deal specifically with real estate. So it's an important topic for you, the real estate investor, to consider on how you can utilize that in your tools and bag of tricks in order to help benefit you in your real estate investment endeavors. And with us to discuss partition actions and what they look like is attorney with the law firm of Fowler St. Clair, Nick Strom. Nick, thanks so much for joining us.
Glad to be here.
So tell us, Nick, and our audience a little bit about you, your practice, and where you're licensed to practice law.
Sure. Well, I've been practicing 12 years. I'm licensed in Wisconsin, Illinois, and here in Arizona. I've done a lot of different types of civil litigation, but with a focus on real estate. I used to represent the Big Four underwriters in title insurance matters. I have a lot of experience representing investors, banks in foreclosures, and even in non-judicial foreclosures. So kind of runs the gamut of the real estate world, my practice.
So I know you are active on social media. Why don't you explain to our audience what the quad father of real estate is?
Sure. Yeah, that's usually the only thing anyone remembers when I talk. But I'm actually the proud father of quadruplets. I have 4 6-year-olds. They're just finishing up kindergarten this week, actually. So just kind of wanted to incorporate that into what I do online. I actually have a YouTube page, and I do TikTok as well. It's under the quad father of real estate. My kids make appearances. Sometimes they ask me questions and I answer the real estate questions. So it's a lot of fun.
Cool. Well, so let's dive into partition actions. And why don't we start kind of with just a basic question? We're going to get into what a partition action is. And maybe this will help explain it, but somewhat of a provocative question. Can one co-owner force another co-owner to sell real estate?
The simple answer is yes. Basically, in a partition action is if people aren't getting along who own the property, they go to court and they force the sale.
So at the end of the day, what you're saying is, so a partition action is just an action that's filed with the courts in order to sever the party's interest in the real estate?
Yeah, and to move on from the real estate. There are different types of partition. Sometimes if you have a large, like vacant lot, maybe the court can order it divided so that people can still build and go their separate ways and just subdivide it that way. But what I primarily deal with is residences, usually single family homes, when perhaps a couple who's not married purchases a home together and they break up, and one party is trying to live in the property, the other party wants to just move on, get their equity. Another situation I see a lot is siblings that inherit a property. They can't agree what to do with the property, so eventually you have to force the sale through court. And another situation that I haven't seen as much is maybe business partners go in on a property and, one of them wants to sell, but, the other thinks, maybe the market's going up or whatever. And that's another situation where I've seen that you have to force the sale.
And we'll get into some of the different types of and ways that we see partition actions. You mentioned kind of historically, partition actions can be done in kind or by sale. In other words, early on, maybe as early as like, common law, heritage history, a partition action might have meant just drawing a line down a property and just literally splitting it in half. In modern day real estate, with the rise of subdivisions and things like that, and planned communities, all those kind of things, is that even really practical to be done anymore, or is really everything done by sale at this point?
Pretty much everything I've seen is done by sale. You got to remember, you would also have some problems if you're subdividing a property, or drawing the line down the middle. What if one side has access to water or some sort of right, and then how much more valuable is that part of the property? And then are you getting experts involved to determine the valuation, different surveyors? So that could be a very costly process. And from an efficiency standpoint, sale is usually what we see. Again, mostly what I've dealt with is the sale of residences, when just two owners, want to go their separate ways.
To Andy's point, though, I mean, a partition, the word partition basically is somewhat, archaic in that it is back in the common law where you actually could partition property, and assuming that all things are being equal and you can actually partition equal parcels of equal value and whatever. I mean, the court's going to favor that, but as things have developed, I mean, aren't we really just, like you said, talking solely about sale? Because now the word partition has really kind of evolved to mean, from a legal standpoint, just this forced sale of the property by the court.
Yeah, forced sale, and then distribution of funds and who gets what out of the equity of the property. Yeah, that's pretty much what it is today.
Yeah.
So let's talk. You mentioned some interest holders where you can partition. And we talked about one, like a non-married couple who separates, so they owned it in common, they separate. What about a married couple? Let's say that, spouses own it, they're going through a divorce. Does partition work in that scenario?
Usually it wouldn't work. The divorce decree is going to deal with something like that. And that would be a prior contract, I guess, that deals with the separation of property. I guess technically it is possible if maybe the real property isn't dealt with, or the parties want to deal with it outside of the divorce, but almost always it's going to be dealt with within the divorce decree.
Yeah. So basically you're saying the family law court and the divorce proceeding would have jurisdiction over that. But if for some reason it wasn't properly dealt with in that proceeding, then, and the party still remained on title after the decree is entered, which means they're no longer married.
Right.
Then at that point, maybe a partition action might work.
It's technically possible, but from a practical standpoint, it's unlikely. You probably don't want to hire a new set of lawyers to deal with the partition outside of it. And, property is a pretty big asset. It's unlikely someone's going to forget to do that, but technically, yeah, it is possible.
Well, it's a lesson, I think, in divorce proceedings. Get that real estate dealt with, because I mean, we've seen cases where, I think we were just talking about this the other day, Sean, where we've seen cases where it wasn't dealt with, or they thought they had some creative way of dealing with it, only to escape out of divorce, think everything's good, and then shocker, realize they still don't want to be on title on the property anymore. And now you don't have the jurisdiction of the probate court, the family courts anymore. It's the civil courts, and now partition's the only way to deal with it. Of course, they're unmarried at that point, but yeah, they're back to dealing with lawyers again and removing each other from title.
I've also had clients come to me, and I've thought about this and thinking, oh, I wonder if something could have been done differently as far as taking title to avoid this. But I've had clients come to me who, because we've talked about, partners, like business, partners, and it breaks down where you have an LLC that owns the property, and you have two members of the LLC, and that's it, right? They each own it 50-50. And now they're not getting along. And they're like, well, the one's like, I just want to sell the property and be out. And, they're like, can I just do a partition action? And I'm like, well, no, I don't think so. It's owned by an LLC. So what does that look like in an LLC context? If you know, like, what would need to be done on, two members as far as the LLC goes?
That is really interesting. The first thing to be done would be to look at the LLC documents, like what they say, how assets are going to be dealt with. And, the one defense to a partition is if there's a pre-existing contract on how to deal with the contract. If two people go in on the property and you agree you're going to hold it for 5 years, 3 years in, partner A can't move for partition because there's a pre-existing contract. So that's an interesting question about the LLC. I've never seen that myself, but I imagine if the documents were drafted properly at the beginning, there's probably a contingency in there somewhere.
Yeah, it really does come down to the operating agreement and what it says as far as the assets and, who can force the sale of the assets and, dissolution and stuff. But a lawsuit involving an LLC and dissolution and, business disputes, I think is a lot more difficult to deal with than simply a partition action. And so in some ways it's like, well, maybe if it's only 50-50 ownership, maybe you should each own it as a joint venture type thing. Now, once again, if the contract of the joint venture agreement says, oh, you have to hold it for 5 years, and one's like, well, I'm out, I'm going to force the sale, that would be a breach of the agreement. And then you would, have an issue there. Interesting.
Explain to us circumstances where partition might be appropriate when it involves inheritance or persons being put on title by virtue of inheritance.
Well, the main issue I've seen with this, and I mean, it's probably not that hard to imagine. Maybe one of the siblings is living in the property, and it's the mom and dad paid off the mortgage. Taxes are reasonable. Why would they want to sell? They have a free place to live, whereas the other siblings, their equity is just sitting in that property, and they can't have something, or they want to do something with that equity. Relationship breaks down, people are mad at each other, and that's really, there's not going to be any resolution among the siblings. So you have to go to court. Hopefully cooler heads prevail after that. But that's the one I see the most with siblings inheriting.
And that circumstance is ripe for investors. We've had a number of investors and lawyers on the show that like to find those deals where you've got multiple siblings that have inherited it. And, most of the time, most siblings just want their money and they want to move on, right? But there's the one that doesn't want to sell for whatever reason. And, we've seen circumstances where investors come in and buy up those interests of the siblings that do want to sell, and then come in and file a partition action in order to, force the sale of the sibling that doesn't want to sell. And of course, you're able to presumably buy those interests from the siblings that do want to sell it at somewhat of a discount because they can't sell otherwise, right? A conventional person who doesn't understand this isn't going to want to typically buy that. So we've seen it as a pretty interesting opportunity for investors. So let's talk about the initiation of the partition process itself. What does that look like? How do you got to get a partition action started?
Well, the first thing I always like to do is I send a demand letter, cite to the case law, cite to the partition statute, and just kind of explain to the other side, hey, this is happening. You might as well, before we file a complaint, let's just, list it and enter a settlement agreement and be done. That's the most cost-effective way to do it. But more often than not, people dig their feet in. So then you file a complaint. If the other side doesn't answer, you'll shortly move for default 20 days after getting service. And then you do have a decision to make if they do file a responsive pleading. I always like to be aggressive. I like to file my motion for summary judgment to get the issue about the sale of the property done. And then what we ask is for the proceeds to be held with the title company or with a law firm until you can do a fair and equitable distribution of the property. And I can go into that if you want. There's some interesting.
Yeah. So let's break a couple things down.
Sure.
You said it starts with a lawsuit. Everybody's somewhat familiar with this concept of a lawsuit. When you say a lawsuit, are we talking about a normal civil action in the courts here in Arizona, the filing of a complaint, what would be similar to any other dispute?
Yeah, pretty much. The statute does have certain elements that have to be listed. So you just list those. You serve all of the owners on title of the property, and then you move towards getting service. Oftentimes, you'll include a separate count, maybe for unjust enrichment or some other equitable remedy. But the partition statute itself in the case law does deal with how proceeds should be distributed.
So let's just kind of, not every listener fully appreciates or understands, what a lawsuit looks like and timeframes and stuff like that. So here in Arizona, let's say that you have a client who comes to you and says, okay, I'm a co-owner on this property. I just want this property sold. I want to get my equity out, or I want to pay off the loan, or whatever the case may be. They just want done. They want to be done with this property. And you send your demand letter. You probably give the other side 10 days or something to respond. They don't respond. So, it's like, well, it's lawsuit time, because clearly, that may be the only thing that, gets them to move. You prepare your complaint, you file the complaint. How long normally does it take to then serve that complaint?
I wish I had a hard and fast rule on that. The process servers work really hard, and usually, they can get it done fairly quickly. Other times you have parties that avoid service. They are possibly living at the property and just not answering the door. And that's always a frustration. So then you have to try and get what's called alternative service. You show the court all the attempts your process server made, and then you say, hey, I want to post it on the door. I want to email them. I want to get it published, put it in the newspaper, mail it to them. It takes a little bit of time when there's avoiding service, just because you got to show that you really made a good effort. There's no real general rule of thumb on service, but you could be looking at between a week and a month. Who knows? Maybe longer. But that's often that's a pretty big hurdle, because getting the sale of the property is actually not that difficult once you do have service.
Well, and to your point, we as attorneys can never advise anybody to avoid service or anything like that. But honestly, if I have a client who's like, I don't want to be served or whatever, it's like, no, you want to be served, because frankly, and this is true of our office, I know, you will be served. The defendant will be served. It's going to happen one way or the other.
Yep.
And they may or may not know that they've been served, but it's going to happen, because, you can serve by publication and different things, but, service will be done. It just may take us a little bit longer, but you will be served. So let's say you get them served, and they're deemed served one way or the other, by hand delivery, by, posting and mailing, by email, by publication, whatever the court allows us to do as far as alternative service goes. We've served them. From the date of service, the date that service is deemed to be effectuated or accomplished, how long do they have to answer in Arizona if they are an Arizona resident? Let's start there. If they're an Arizona resident, how long do they have to answer?
20 days. So, and then after that, you if they don't answer, you would move for what's called default. Basically just what it sounds like. Hey, court, they're not responding. Why should I have to do anymore? Give me my judgment. There's 2 steps to default. Depending, and again, there's no set time that's going to take place. Because courts get busy, things get backed up. You file as soon as you can, but then you're at the mercy of the court for how long it's generally going to take to get to a default hearing.
Well, and they even get an extra time period. So they have 20 days to answer. And here in Arizona, this isn't true in a lot of other states. In fact, most states don't have this. They have 20 days to answer. And then if they don't answer, then on the 21st day, you file, you can file an affidavit of default, basically saying, hey, look, court, they've not answered. We want default to be entered. And then they receive an additional 10 business days. Is that correct to answer?
I'd have to look at the statute to be sure, but I believe that's right.
Yeah. So basically, all told, they get like 35 days to answer, and then you can go and get your default judgment. Then you're at the mercy of the court, right?
Right. For when they actually scheduled the hearing.
So let's just break this down and put a rough estimate on it. So all told, if I wanted to go and do a partition action and I, employ Nick Strom to do it, who I know is Johnny on the spot with everything. And I hire him from the date that, we start the lawsuit to the date that I get my judgment. What are we talking? 90 to 120 days, roughly?
Usually that is the case. If you're getting a fight on the other side, it's obviously going to be longer. But I've had situations where people, they file the answer and they respond to the motion for summary judgment. They request an oral argument, and it really drags out. But 90 to 120 days is reasonable to at least get to the point of the judgment for, in most cases, judgment for sale. Now, distribution of proceeds is a separate matter.
Oh, yeah. And so let's talk about that. So you have, basically, it sounds like you have two components to a partition action. You have the sale of the property, and then you have a distribution of the proceeds and who receives what from the proceeds. Let's start first with the first component, the sale of the property. You mentioned, sometimes I get an answer and a response to a motion for summary judgment with oral argument. Is there really any defense to the sale of the property? And if so, what are those defenses?
The real defense is if there's a pre-existing contract to deal with the property. And that's like we were talking about before, the partners who buy the property, we're going to, own it and rent it out for 5 years and sell it and get the sale proceeds at the end of that. Well, 3 years in, if one partner is sour on the other, they can't just partition the thing. They got a prior contract. So that's really the defense you're going to see. Obviously it's rare, but that's really the only thing. Of course, people can allege there's a contract that for the purchase of the property that doesn't exist, but there's counter arguments to that as well. And then they run the risk of getting hit with attorney's fees if you can prove there wasn't a contract.
Well, yeah, let's talk about that. Are attorney's fees normally awarded in partition actions?
Unfortunately not. That's why you try and be cost effective with the demand letter at the beginning and negotiate and get the thing worked out. However, Arizona has a fee shifting statute that basically if there's a contract, the court is allowed to, it's discretionary, but can award attorney's fees. Now, the opposite is true too. If someone alleges that there is a contract, but in fact it is proved that there is no contract, then the party who proves there was no contract can get attorney's fees. It's important statute because the allegations of the contract are going to really slow things down. There might be issues of fact that prevent a motion for summary judgment. So people alleging the contract better be very sure there's a contract.
Yeah, that's a sword that really cuts both ways. And I can imagine a scenario where as a defendant, you got to be real careful about playing games on that one, because the temptation is, and we can get into the strategy behind this, the temptation is to do what you mentioned, create some sort of issue of fact. Oh, we had an agreement to hold this thing for 10 years, and then it'd be a buy and hold, and we'd sell at the end of that, and we'd split the equity, something like that. If you just by alleging that, you've taken a case where all of the parties have to bear their own attorney's fees and costs. But now, because you've alleged a matter arising out of a contract, if you lose, it's not just selling the property anymore. It's selling the property, and you may be paying for the other side's attorney's fees, right?
Exactly. It's super dangerous. And you got to remember, this is the sale of real property. So the statute of frauds is going to come into play. So you got to be really sure, and for the listeners, the statute of frauds requires certain contracts to be in writing. Real estate is one of those things. Now, there are exceptions to the statute of frauds, but it's a pretty big, it's very helpful when you're saying there isn't a contract if there's nothing in writing. So I think it's a real uphill battle if you're arguing that there's some sort of oral contract that prevents the sale. You can really do a disservice to your client if that's what you're arguing.
Well, and the implications I think are pretty big. So let's break this down, because you mentioned strategically in a partition action where you like to file a motion for summary judgment. And for the listener, that really means, from a lawyer and a judge's perspective, the facts are for juries to decide, the law is for judges to decide. And in a case where there's really no dispute on the facts, we all agree as to what happened, which it is common in a generic partition action. I own 50, they own 50, or whatever the percentage is. Court, we just want you to split it. There's not a big dispute on that. And that can be resolved in an somewhat expedited fashion. And by expedited, I mean, it doesn't have to go all the way through the end of a jury trial.
Right.
But you allege a contract and create an issue of fact, and those issues of fact have to be decided by a jury. We might be talking about the difference of $10,000, $15,000 in fees and $150,000 in fees. I mean, that's a huge difference. And I think a lot of people unwittingly, because of the Arizona fee shifting statute on matters arising out of contract, unwittingly fall into that just because they're being cute, right?
Yeah, and another thing to think about too is there's also ARS 12-349. Basically, you can't just you can't unreasonably delay litigation or do things that aren't done in good faith. So it's really like, well, if you're just trying to remain in the property and not pay rent and stay in there as long as you can, are you running afoul of that? And that's an even stronger statute, because the judge doesn't have discretion to award attorney's fees if the defense is for no substantial justification, which is defined in the statute. And there's also a statutory penalty involved. So like you said, if they're just getting cute and trying to delay, I mean, they are really putting themselves at the potential for a huge attorney's fee award.
But let's say hypothetically that you go forward with the partition, the other side, doesn't allege the existence of a contract, which in that case would mean there is no defense, right? I mean, but maybe they're, you win on your motion for summary judgment. The judge says, yep, property's going to be sold. And the other side's like, oh, that's good and all, judge, but you've issued this piece of paper telling me I have to sell the property. Why don't you, grab my hand and force me to sign? Like, you can't do that. It's just a piece of paper. Like, how does that work? So what happens if the judge enters a judgment and one side is uncooperative with the sale of the property? What does it look like moving forward there to get the property sold?
A lot of that's dealt with in the order that grants the sale of the property. A real estate commissioner is appointed. Usually we just use a realtor who's familiar with the market. And if someone is holding out, there can be a fee shifting award. The real estate commissioner can get higher percentages out of their portion of the sale proceeds. There can be sanctions, attorney's fees. There's usually a provision in there where you can bring a motion for expedited hearing to force the sale. And if they're still refusing to sell, you can get the real estate commissioner or a title company to be allowed to sign on their behalf.
So once the judge finds that the property is to be sold and they enter an order to that effect, you might be able to delay it a little bit, but you can't stop the sale. It's going to happen whether you sign, you show up to title and you sign, this property's being sold. And so you use the term a special real estate commissioner. What is a special real estate commissioner for those watching that, may not understand that term?
They're the person appointed by the court to oversee the sale. There are specialists who work in that, but I've always just used a local realtor. I feel like they know the market. They're usually good with people. Maybe they're able to even talk to the party that is holding out and say, look, I hate that attorney too, but he's making you sell. So, I'm your buddy. Let's get this thing sold. And I've actually had a lot of success with realtors being able to kind of explain the situation, calm the situation, and move the case forward with a sale.
So basically, the court appoints basically a realtor as a special real estate commissioner who then, lists the property for sale, finds a buyer for the property, basically acts as the real estate agent for the parties, and then sells it. Now, are they paid a commission then to do that?
Yes. Usually what we do is they just take their standard commission as a realtor. That's what I've always had done in the past. But there are other ways to do it.
Okay. But they're paid. They're compensated to serve in this capacity. Normally they're paid whatever, you on average would pay a real estate licensee. They're paid that. And of course, when you seek to have them, because you name them as who you want to be appointed, and the other side would have to object. So what their fee is going to be and probably get that fee put in the order and that type of thing.
Yeah, exactly. Sometimes the judge doesn't want to go, especially if there's someone on the other side with the one person you nominate. So you submit a blind list. Maybe each person gives 3 or 4 different people and the judge just picks. You list them in alphabetical order. So, and the judge just picks.
So now the property's sold, funds are placed on deposit, but the parties can't decide who gets paid what from the sales proceeds. Now, in my basic view, if I own 50% of real estate and somebody else owns 50% of real estate and we sell it for $200,000, I should get 100, they should get 100, right? I mean, shouldn't it be that basic?
You would think, but no, that's why there are lawyers involved. It gets a little more complex. The standard is fair and equitable. It's an equitable action. So there's not necessarily a set fixed way to do it. However, you are entitled to contributions you make that benefit the joint tenant. For instance, let's say you bought that property for $200,000 and partner A made all of the mortgage payments, all of the utility payments, all of the insurance payments, that he would be or she would be get compensated for that prior to any other distribution. There are other things involved. For instance, if you own with someone else and you pay for an improvement, maybe you build a gym into the house and it costs you $20,000. It's not that you paid the $20,000 in that case, it's the value you increase the property by. So if that gym increased the value of the property by $10,000, that would be what you would be able to recover, not the full 20 you spent. There are other interesting issues, like, for instance, ouster. If someone is preventing the other party from accessing the property, then they'd be entitled to, if there were 2 owners, half the fair market rent. If there were 3 owners, a third of the fair market rent. So there are, it's real property. And I know you guys practice a lot in it. Strange things happen. So there's a lot of interesting scenarios out there. But that's just a basic overview of how it goes. And then if there was any remaining equity, it'd likely just be split 50-50.
Yeah. And, Nick, let me know if you see this any different, but in my experience, the questions of fact in these type of cases really fall along this side of the equation more often than whether a partition is itself appropriate due to some defense of an agreement or whatever else. Usually, maybe there's something like that, but usually in my experience, there's not. But there's almost never a circumstance where they both all equally paid into the mortgage, or they both all equally, because that's usually what they are. They've been listed as joint tenants usually, so they're 50-50 owners, and did they equally improve the property? Did they equally pay for the utilities? Did they equally put in the artificial turf in the background? All that kind of stuff. And the answer is almost never, yes, they equally did it. And that's really where the devil's in the details.
Yeah, I agree. I never really see where it's split 50-50. That hardly ever happens. I mean, just in the investor context, if you think about it, party A maybe is the money and party B is the sweat equity. It gets interesting because what's the sweat equity worth? If they were living in the property like a live-in flip to fix it, they'd be offset by rent. But what's the fair hourly wage for the work they're doing versus the mortgage payments made? So yeah, that is.
I saw a matter once where the sweat equity was alleged to have been all according to some arrangement that they all worked out, but the sweat equity was, well, I would buy all the groceries and do the cooking.
Yeah.
And that's what they did. And there was no dispute that they went and bought the groceries and did the cooking. But the idea was, okay, you pay this and I'll go take care of this, and that's, you don't think about that, but there's some wild kind of sweat equity ways to arrange, who's going to basically pay their fair share, right?
Yeah, exactly. And what actually counts? I mean, does that cooking and buying the groceries benefit an obligation of the joint tenant, so it applies to the contribution of the money? I mean, it depends on the fact scenario, obviously, but yeah, it gets wild.
So once you have the real estate commissioner, now you mentioned, is the real estate commissioner somebody who is credentialed with the court, or can you pick any real estate commissioner?
I've picked just general realtors in the community who are familiar with the community, who will be, I mean, who else is better to sell the property? So that's what I've gone with in my practice.
Now, how often are you able? Now, you can pick anybody, assuming the parties will reach a resolution. How often do you think these matters basically reach a settlement before the court forces the appointment?
Usually people come to their senses, and it gets resolved before there is a hearing on equitable distribution. Just, think about all of the things that we've talked about, the costs involved, the attorney's fees shifting, just wanting to be done dealing with lawyers and dealing with litigation. So usually people, like, I would say 95, 98% of the time, it gets resolved prior to a hearing on distribution of funds. It does occur, though, where maybe it's 50-50 that I do have to file the motion for summary judgment to get the order to sell, because people just aren't willing to listen. There's no way you can force this sale. Like, it's my house, that sort of thing. But once you're before the judge and the judge is like, no, it's going to be sold, then that does happen. Maybe like 50-50. I probably got to go through that part.
Now, this is kind of a high level issue, but frankly, I'm not even sure how to deal with it, because the times that we've had it, the person is, voluntarily vacated the property or whatever. But what about like the example Andy mentioned before, which is, 3 siblings inherit. One of those siblings was living in the property with, the parent that passed away. They're like, well, I want to just continue living here and not paying any rent because the mortgage is paid off. And this is a good deal for me, and I'm enjoying the house and, type of thing. And the other two are like, no, we really need you out. Can they now, if a special real estate commissioner is appointed, this person's in there without a lease. They're what we call a tenant at sufferance. Mm-hmm. They're without a lease. They're just there occupying this property. And while they're on title, they have every right to possess it. I mean, they're a title holder. Right. But the minute that the property sells, the new owner owns it, and the other, heirs don't own it, including the one that's occupying it. What is done to, move them out of the property prior to the closing of the sale, number one? Or number two, does that just become the new buyer's problem, and they're going to have to evict the, heir that's squatting there in the property at that point?
Yeah, the statute actually provides for this. And I want to say it's subsection 1218D, but I don't remember the statute off the top of my head. But basically, as soon as that sale takes place, the new owner can go to the court and request a writ to have them removed. They don't have to go through the eviction process. It's already done, and the court orders it, and then the sheriff comes out and moves them.
Oh, so if you purchase something that's subject to a partition action, you can go and somehow intervene in the existing action and be like, hey, look, judge, this person is still living here. I don't want to have to go through the eviction action. Can you just give me a writ and get them out?
Yep.
Interesting. Okay. Yeah. So the statute already has thought about this. What happened?
Because you can imagine, like, just why would they leave? And then what does that do to the value of the property? Wait a second, I got to buy this and move and deal with these people. Like, it's just going to crush the value. But, if the seller is willing to stay in and maybe like, look, I will go to the court for you, get this writ, get it on your behalf. And that, maybe sweetens the pot a little, moves it along.
Oh, okay. So the seller or maybe even the special real estate commissioner can get the writ. And can they get the writ in advance of the sale so that the writ is like exists, and is already, ready to go?
I think the sale has to go through first.
Okay.
Don't quote me on that. But also, if you think about it from a 30,000 foot view, you can account for this in the order as well. If that sibling is going to be receiving equity, you can just put something in there. Every day they hold over, it's $100, and you're just going to be taking it out of their equity at the end anyway. So it's a poison pill. If they want to stay in there, fine. We're going to get you out with this writ, and we're going to reduce the amount of equity you're going to have. So, what do you want to do? Right.
Oh, yeah, I like that. That's good planning.
Nick, you mentioned ouster earlier, and it made me think of a hypothetical that I think more co-owners might run into than we'd like to think. But the traditional idea of an ouster is we both own the property. I kick you out. I change the locks, and you're not allowed to have access to the home anymore. But because you're a joint tenant, you're supposed to have unfettered access to the home. So you should be entitled, if I do that to you, to your share of the reasonable rent, or I had to pay that. But what do you do in circumstances? Because a lot of times unmarried individuals find themselves in a partition action. Okay. So those facts that led to a partition action oftentimes are similar facts that might lead to a divorce. Mm-hmm. And where I'm going with this is, what does a co-owner do that doesn't feel safe in a home anymore? Let's say they've got a boyfriend or a girlfriend, for that matter, who they don't feel safe around, and they feel the need, I have to leave just for my own safety. Are there facts that can arise that basically are tantamount to an ouster? In other words, I haven't locked the doors, but I've acted in such a way that I've made this really an unlivable place for the other person, and thus it constitutes an ouster. Is there anything like that?
Yeah, so I have seen that situation before, and I argue it's an effective ouster. It has all the hallmarks of an ouster. And remember, the standard in a partition action is fair and equitable. So let's imagine a horrible scenario. Maybe it's domestic violence, and one of the parties has to leave the property. It's like, well, I didn't say the other person had to leave. And I just don't find it fair and equitable that someone has been driven from the property for their safety, and they shouldn't collect for ouster. I can't. Fortunately, I've never had to go to an evidentiary hearing on that issue, but I can't imagine a reasonable finder of fact not giving sympathy to that sort of a situation.
Sure. No, I think that there can be circumstances where the facts can justify or be proved to be effectively an ouster of the property. If you can't legitimately use all right, title, and interest of the property you're a joint owner in, and it's not safe to do so. Yeah, I agree. I would argue that constitutes a legal ouster. Nick, thanks so much for being on the show with us. We really appreciate it. Covered a lot. Remind our audience how they can connect with you, find you, if they want to bring a partition action or learn more about the process, or just have a chance to talk with the quad father of real estate.
Sure. Well, I'm on our firm's website, FowlerSt. Clair.com. I also have my YouTube and TikTok. That's the quad father of real estate. The quad father of real estate law, excuse me. And reach out. I love to talk about real property. It's a endlessly fascinating field.
All right. Thanks so much for being with us, Nick. Looking forward to doing it again with you.
Sounds great. Thanks,
Nick.
All right. With that, everybody, that is our show. Make sure to join us next week for another live episode of the INREM podcast. We'll see you next week.
Have a good day, everyone.